it's going to be a busy day today for the Illinois Supreme Court. They are hearing the arguments about Illinois' no-cash bail law that was set to go into effect January 1st, but has been suspended pending an appeal of a Kankakee County Court ruling the law was unconstitutional. Good morning, I'm Greg Bishop. It's now 6:11. You can always call in live and local at 217-629-7970. You can also email me, bishoponair@gmail.com, and you can find me on all of the various social media channels. Just search everywhere for Bishop on Air. So we've got today's hearing where, anticipating it to be pretty early on with the slate of docket take-ups that the Supreme Court has in front of them. And you've got the history of the no-cash bail law, part of the Pretrial Fairness Act that was part of the sweeping criminal justice reform and police regulation bill, the Safety Act. And if you recall, that passed way back in January of 2021 under the 101st General Assembly. And that was right before, in the final days and hours of that General Assembly, early January. They were actually over at the Convention Center for the Illinois House. And if you recall, Mike Madigan was still Speaker of the House then, just before they switched over to the 102nd General Assembly, where Speaker Welch took over Speaker Madigan's position. So at the tail end of the 101st, you had the Legislative Black Caucus get these ideas together for the Safety Act. It included a whole host of things requiring body cameras for police, providing for a lot more regulation on police. And then you have the Pretrial Fairness Act portion of it that dealt with criminal justice issues such as people who are arrested for a crime. They're innocent until proven guilty. And the argument is they should not have to languish in jail while innocent until proven guilty, pending trial, while people who are also arrested, innocent until proven guilty, are able to afford to bail out. So that's the argument of the no-cash bail law. But you had state's attorneys from across the state, even back in early January when the measure was brought up, and we're going to talk a lot more about this in some detail, but just some background in as far as where we're at today heading into the Illinois Supreme Court ruling. You had state's attorneys for, the whole span of the time from when it passed to just before the end of the year last year, raising concerns about no cash bail and its impacts on criminal justice system, on local county jails, and on public safety. And they ultimately, even after multiple changes to the law, even after an election and even more changes to the law to create a broader net of detainable offenses, didn't ease the concerns, and those concerns were still there. So the state's attorneys across the state sued, and you had the Kankakee County judge declare that the Pretrial Fairness Act and portions of the Safety Act were unconstitutional because it violated separation of powers and also violated the Victims' Bill of Rights in the Illinois Constitution. So you've got that going to be heard today in the Illinois Supreme Court. You also have in the Illinois Supreme Court set for mid-May the challenge against Illinois' gun ban. And that's from Macon County, where a couple of weeks ago you had the judge there declare that the gun ban was unconstitutional. In a direct appeal up to the Illinois Supreme Court, you've got various briefs that are going to be filed, and then also you've got the hearing that's going to happen sometime in mid-May at the Illinois Supreme Court. Governor J.B. Pritzker was asked about both of these cases and his level of confidence, and he shared some of his thoughts about the Safety Act, about the gun ban challenge, and he was not asked yesterday at an unrelated event up in Chicago about the $1 million donations that he made to then Supreme Court candidate justice candidates, and those candidates eventually got elected and are on the bench. It'll be telling to see if they are on the bench for the hearing on the Pretrial Fairness Act, because Pritzker is a top donor to them, and he's also a top defendant in that case, as is House Speaker Emanuel Chris Welch, a top defendant in the case, also a top donor to these Supreme Court justice candidates. governor was not asked about that as I asked him about that last week. But here's the governor's response to the question posed to him up in Chicago.
Last week, the Supreme Court accepted an appeal on the assault weapons ban out of Macon County. Tomorrow, oral arguments in the Safety Act case. How do you feel? What are you concerned with these two major pieces of legislation that you find hanging in the balance based on what the court decided?
Well, I know, it's the last refuge of those who can't win at the ballot box to take something to court to try to have it overturned, even though they are wrong when they say it's unconstitutional. As you know, this is the law, at least talking about the assault weapons ban, it's the law in 8 other states. Illinois is simply the 9th, and we're trying to protect people. It doesn't protect people everywhere all the time for, from firearms, but it does protect a percentage of people, and I think we'll do something to keep the people of Illinois safe. And I think the Supreme Court is going to give it a fair hearing, but I can tell you that all the lawyers and people who are involved in crafting the legislation feel confident that it'll come out the right way.
And on cash bail, what's at stake if the court overturns the law that
I don't expect that they will overturn it. There's no rationale that makes any sense to overturn it. So I'm looking forward to that becoming law.
So again, that's Governor J.B. Pritzker responding to questions in Chicago at an unrelated event where he was signing paid time off for all employees. And part of that response was more focused on the gun ban legislation that is challenged now up to the Illinois Supreme Court, but it's still going to be weeks before we actually have that hearing. But today, you've got the hearing in front of the Illinois Supreme Court on the no cash bail law that was suspended just before the new year. Ultimately what you had happen is you had the no cash bail law pass, amended several times. Kankakee County Court declares it unconstitutional. Then the Illinois Supreme Court said that right before New Year's, on New Year's Eve, the Illinois Supreme Court suspended no cash bail statewide, saying that it would have caused chaos if there was a patchwork of counties that were either not having cash bail or were having cash bail. So we'll be watching that closely. But just to revisit what State Representative Patrick Windhorst said the arguments are and why he says that ending cash bail will harm public safety. So stay tuned. We'll get to that coming up here next with Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. Been highlighting the Safety Act's no cash bail provision that's in front of the Illinois Supreme Court this morning. And a commenter on Facebook and YouTube streams asks if I'll be there. Yeah, I'm going to be covering it, absolutely, and getting out the latest and some of the reaction. We're actually going to be talking with the American Bail Coalition live a little bit later on this morning, so stay tuned for that. But shared this yesterday, wanted to bring it back up just in the context of what we heard from Governor J.B. Pritzker when it comes to his assessment of the court case and his assessment as well to what exactly he thinks is going to happen with the no cash bail law. He says that he believes it's constitutional and it'll withstand constitutional challenges. But when I talked last week briefly with Illinois State Representative Patrick Windhorst, he said that he's got some confidence that the prosecutors who brought the challenge against no cash bail will make their case heard in court today.
Well, as we and others have argued throughout this process since the Safety Act has passed, our state constitution envisions a cash bail system. We are going to hear arguments from state's attorneys, I believe out of Will and Kankakee County, who are going to put forward the argument that the ruling of the Kankakee County Court was correct in saying that the elimination of cash bail violates those constitutional provisions and also violates the separation of powers. The courts have the authority to operate and administer the court system. Bail has been held to be an administrative function of the court, and it's not something the legislature can impede upon. That, I'm anticipating, will be the argument of the state's attorneys in that case. Of course, the state has argued, the Attorney General, that the prosecutors can't even bring the case because they've not been harmed by the law. I don't believe their argument on the merits is strong. I think their argument is more toward a standing situation. What we believe will occur with the elimination of cash bail is people will be released very soon after committing serious violent crimes, which is going to lead to an increase in the crime rate, an increase in recidivism, and a lack of accountability for those committing crime.
So Patrick Windhorst, Republican from Harrisburg, kind of laying out what he believes are going to be some of the arguments back and forth. The Supreme Court taking up those arguments today in the Illinois Supreme Court here in Springfield, and still yet to really be seen. I guess we'll get an indication when the justices head to their seats at the bench, and that is if the two Supreme Court justices that received $1 million each from Governor J.B. Pritzker, who is a top defendant in the case, if they're going to recuse themselves. It's not necessarily in the judicial canon for the code of conduct, but it's something that independent observers I've talked to have laid out that any air of conflict breeds a conflict of interest, and it can also lead to a distrust of the judiciary and any potential decisions that they make if there is that possible conflict carried through. So you've also got, big donations from House Speaker Chris Welch to these two Supreme Court candidates when they were running for the office. They won in November, and now they sit on the bench. But Chris Welch, his campaign fund gave these two candidates $150,000 to one, $350,000 to another. He's a top defendant in this challenge of the state's no cash bail law. So you've got the ongoing questions, and are we going to see recusals? Recusals aren't uncommon. They really aren't when it comes to Illinois Supreme Court decisions. You'll see if you pull up recent decisions, two of the three from, I think, February, there were, two recusals in a couple of different cases where it just said that, such and such justice took no part in a decision. So is that what we'll see? But if those justices don't take part in the decision, will they take part in oral arguments? That is yet to be seen. We'll watch that closely here with Springfield's Morning News on 92.7 WMAY, Springfield's News and Talk. And if you want to follow along with me as I report out what happens, you can also follow me on Twitter, Bishop on Air. It's a great way to stay up to date live, so be sure to check that out. And we'll be updating you all throughout the day.